And this might not necessarily be peculiar to California, although that's where I practice, and people who call me from Michigan, let me say I appreciate that you watch the videos, but I can't give you legal advice if you're in Michigan. What I can say, however, is if you have vendors and suppliers, once they learn of the Chapter 11 filing, they may be a little bit spooked. So in this context, we like to make a distinction between ordinary vendors and what are called critical vendors. Well, the term critical vendor doesn't really come up in the bankruptcy code. It's kind of a term of art that is used in common parlance in the bankruptcy world. The idea behind a critical vendor is that vendor is critical to the survival of the business. So let's say you've got a vendor that's producing and selling you widgets, and without these widgets, your entire business comes to an end. That's a critical vendor. And so we want to make sure that that critical vendor doesn't just sort of pull up stakes and leave. So typically what we do is get the court's permission to treat that critical vendor better than other vendors. Now, in order to understand what's at work here, we have the day we file the bankruptcy petition as the petition day. Prior to that, it's pre-petition. After that, it's post-petition. Any debts that the business has that were incurred pre-petition, you can't make payments on until the plan is confirmed, and then the plan will have a way of servicing that debt. So what happens if you have a critical vendor who's sold you some merchandise, you file a petition, that vendor hasn't been paid? Well, that's going to be rather awkward. And you need that vendor to stay on board. So you can go to the bankruptcy judge and ask permission to pay that critical vendor for the materials or the merchandise or whatever it was that you received, but didn't pay for, so that that vendor doesn't have to wait until confirmation of the plan, which can take many months. Typically, if you can convince the judge that that vendor really is a critical vendor, you'll be able to do that. Now, if you don't do that, well, the critical vendor has some recourse under the Uniform Commercial Code. One thing that the critical vendor can do is, if the goods are in transit, have them stopped and returned to the critical vendor. Another is, if the goods were delivered within 20 days of the petition day, well, in some cases, it's up to 45 days. Critical vendor can reclaim those goods. So it's absolutely crucial to keep that critical vendor happy. And that's why one of the first day motions that we file is, first, before we file the petition, we identify who the critical vendors are. And then in that first day motion, we will identify the critical vendors and say, Your Honor, we really need to service this pre-petition debt. Otherwise, these vendors will not supply. And if they don't supply, we're dead in the water. So other vendors, well, it's going to be on a case-by-case basis, whether a vendor or a supplier is willing to cut the business some slack, seeing that it's in bankruptcy. Could be that with sufficient assurance, look, we understand that we owe you money. We're going to provide for you in the plan. We'd like to continue our relationship. They might be willing to hold off on cutting off the relationship with enough assurance. And sometimes we use something called adequate protection, again, with the judge's intervention, to take money out of the bankruptcy estate to keep that non-critical vendor happy. And perhaps I should make a comment on the estate, because I've used that term several times. And I think for the general population, when they think of the estate, they think of either the wealth of some fabulously wealthy person, or they think of what is the corpus of assets when someone dies that's going to be distributed among the heirs. So in bankruptcy, the term estate has a very specific meaning. To appreciate what's going on, before we file the petition, the debtor has assets and the debtor has debts. When we file the petition, that act creates the bankruptcy estate. And what goes into the estate is all of the assets of the debtor. And then the debts become claims against that estate. And of course, the debtor is required as part of its fiduciary duty to manage the estate, not for its own benefit, although undoubtedly this will inure to its own benefit, but for the benefit of the creditors. So when we're talking about taking stuff out of the estate, we are taking stuff that could be used to pay those claims. And that's one of the reasons why we do have to get the court's permission. Long and short of it, though, is if you have a good long-term relationship with a vendor or supplier, and that vendor or supplier is a critical vendor, chances are we'll be able to work things out so that the relationship will not be changed.